Hello, everyone. Welcome to Asala's Classroom Talks. Today, we are privileged to be joined by some of the finest minds in family law and succession, and they will be helping us in engaging in this conversation on how to protect children in divorce and succession matters. So welcome on board Dr. Celestine Musembi and Evelyn Kokimbulu. And perhaps I will request Dr. Celestine, please go ahead and introduce yourself.
Hi, good evening, everyone, and thank you for your patience. I'm Dr. Celestine Nyamu Musembi, and I teach law at the University of Nairobi Faculty of Law. I teach courses in family law, in property, and in international human rights, and also gender and the law. And I'm happy to be here. Thank you.
Thank you very much, Daktari. We will now come to you, Evelyn, and thank you very much. I must appreciate you making this time just to join us. I know it's been a long day for you, but we truly appreciate. Please introduce yourself.
Yeah, Ms. Kokimbulu. I am a practicing advocate. I also teach family law together with Dr. Celestine. I also teach the law of succession. I teach trial advocacy. I teach communication skills. And criminology and penology, which is an area I'm interested in for my PhD. That is what I do.
Thank you very much. Now, without wasting any more time, let us get into this discussion. But before we narrow down on issues, divorce and succession, perhaps let us begin off by, just looking at parental responsibilities. Yeah, when a child is born, parental responsibility begins. Maybe to you, Dr. Musembi, when does this stop? When do we say that parental responsibility stops at this stage in life?
So in general, parental responsibility stops at the age of 18, which is the age when one ceases to be a child. You know, the definition of a child in our law, like Article 260 of the Constitution, and then in the Children Act. So that's a general rule, 18. But there are circumstances under which the law can extend parental responsibility beyond the age of 18. And that's laid out in the Children Act. It's when a person who is over 18 is still pursuing a program of education or training, and therefore they need parental support, or they have an ailment whose medical treatment will continue beyond the age of 18, and therefore they still need that parental care, or they're a person with disabilities, in which case then the parental responsibility goes on for as long as the need persists. Right? So that's,
Thank you very much. Thank you very much for helping us to understand this, that parental responsibility in certain instances, it extends beyond 18 years. Now let's get into matters of children rights and divorce. And of course, no one gets into a marriage relationship with intentions of divorcing, but life happens and, people find themselves divorcing. Ms. Koki, why is it important to center children in discussions about succession and divorce?
With regard to divorce, it's a very sensitive matter because a lot of people, particularly in this country, don't like to even say the word divorce. Most marriages are irretrievably broken down, but people opt to stay in abusive relationships, broken down marriages, just to protect children. But the question is subjecting children to trauma that they may experience, when parents are constantly fighting, feuding, or disagreeing, even healthy for the children. In as much as marriage is revered in Kenya, and everybody talks about it, and people should get into marriage, we need to note that children's health, particularly mental health, is crucial to their development. And so that if parties are not agreeing, in terms of, what a good marriage is, if you don't agree, then I guess the best way forward would be to divorce, not just to separate. But separation could also be beneficial to the children. But then divorce is preferable where people cannot agree. and they have irreconcilable, the marriage has irretrievably broken down. And this is because, I guess, that fosters the proper development of the children, emotional health, financial health, in terms of a party being obligated to provide for the children through court-ordered processes, which perhaps will be initiated after the divorce. When people still live together, how do you even file? Okay. Now, in succession, what was the second question? You asked me to.
Perhaps. No, I had asked you to bring out, the importance, why should the children be at the center of our discussion when we talk of matters divorce and succession. But it's important that at least you have touched on divorce, and you brought out an issue on separation and divorce. Perhaps just help us understand what is the distinction between the two.
Yeah, to separate means to live apart without the marriage contract being legally terminated through a court process, through a court order on dissolution. To divorce means that parties have initiated through a divorce petition the requisite proceedings in a court of law or in the Cathy's court for the termination or the dissolution of their marriage. And perhaps they are basing their petition on the known grounds for divorce, which include cruelty, adultery, incurable insanity, exceptional depravity, desertion for a period exceeding 3 years, and irretrievable breakdown of marriage, which is many grounds which are stipulated in Section 66, subsection 6 of the Marriage Act.
And Koki, what should anyone know? What should every parent know before seeking custody of children after a divorce?
I think the question of custody, if you ask me, is a crucial one, and particularly at a time like this, when people are always complaining of the economy. Custody goes hand in hand with, first and foremost, financial provision for the children, and even availability to take care of the children. I know most Kenyan parents and households focus on money, and money is crucial because then you are able to buy the basic necessities of life, from shelter to food to school, paying for school fees, uniforms, books, etc., etc. But then the parent that is given custodial rights over children, or in respect of the children in proceedings, I guess, in the children's court, should also be available to parent the children. You cannot parent children using nannies or remote parenting, just using a phone and constantly calling in to find out whether this or the other has been done. Is the parent available? And in as much as we like nannies and we call them aunties in our jurisdiction, but they are not vested with the responsibility or custodial duties of your children. By the law, it is you. So are you available? Yeah. And that's a crucial question. And maybe Sele can extrapolate on this, because she knows.
Maybe we can also.
Most working parents are very busy, but should they not provide time to parent their children?
Maybe Celestine, you can also just chip in and allow us to hear your voice on this.
Okay, thank you. I think Koki has the liberty to call me Sele because she was my classmate in undergraduate. That's how everyone called me. So anyone else who knows me in a different capacity is wondering.
I'm very sorry. I'm very sorry. I should have said Dr. Celeste.
That's all right. It means we've relaxed into the conversation. No, that's all right. Okay, so you had asked what any person needs to know before they seek custody of a child. I think the first thing they need to know is that the central consideration is the child's best interest, right? It's not about whether as a mother I have rights, whether as a father I have rights. The center is not parental rights, right? And we have come from a past where that was the case, where there was some rigid sticking to rules about the mother has entitlement to custody when the child is of younger years or tender years, and then later the father. Or in fact, the way in which in some customary laws it works, the father has custody automatically if the bride price has been paid. So people have those notions in their heads that when you go to court, you already know whether you have a court or to any alternative justice forum, that you know the custom is on my side or the law is on my side because I'm the father or because I'm the mother. That is in the past. Okay. The central consideration is the best interest of the child. So in fact, under the Children Act, the court may actually even award custody to somebody else who applies and not the parent, if the court deems that in those circumstances, that's what's in the best interest of the child. So the first thing you need to know is the best interest of the child. Yeah.
Okay.
And then
So
secondly,
in other words, just a minute. In other words, the best interest of the child trumps even parental requests, where the court deems that when balancing the two, the best interest of the child should supersede or come before the parental rights, where the parents are both asking for custody.
Yeah, the way the law expresses it is that the best interest of the child is the paramount consideration, right? In any proceedings, whether it's a divorce proceedings or in fact it's a proceedings where the child hasn't got any parents and they're considering a foster care and all that. Always in any proceedings involving children, the paramount consideration is the best interest of the child, right? So in the case of divorce, it's not about any parent's automatic right. It's the best interest of the child that will prevail. Yeah. So when I said that, the second thing is to know that custody is not always tied to maintenance. Yeah. So again, in our popular imagination, people tend to think that if I haven't got custody rights or haven't been able to have access to the child, I'm under no obligation to pay, for child maintenance. That tends to be the attitude, say, with maybe in cases where there's separation or there's even, divorce, and maybe even if an order has been made by the court, we have this deep-seated thinking that if the child is not here with me, if I have no control over the decisions over the child, then don't ask me for money to pay for maintenance of the child. The law delinks those two. The right of the child to maintenance is not conditional on whether you have managed to have access to the child, whether you have managed to have custody. The child's entitlement to care is unconditional, to maintenance is unconditional.
Okay, thank you very much. And now allow me to take, maybe Koki, you can take us up on this. A situation where the parent who has custody of the children, remarries with the children and unfortunately they die. Yeah. And now we are having a tussle where the best interest of the children is being considered between, the adoptive father or, the stepfather and the biological father. In this kind of scenario, are we still going to listen to the best interest of the child even when it is contrary to the wishes of the biological father?
But the best interest of the child is a constitutional tenet under Article 53, Sub-Article 2 of the Constitution. It's called the paramountcy principle. And just to follow up on what Sele had said, it doesn't matter who has custody. Both parents equally responsible, for paying for their child's, financial needs. And I guess even the obligation of parenting. But then it's between maybe a mother who remarried and, is she the one that has died leaving the stepfather and the biological father fighting for the children? I guess the best interests of the child are still paramount. And it's between the rights of the stepfather and the biological father. If there was a case, I'm imagining, the court would be more inclined to grant custody to the biological father as opposed to the stepfather, and particularly where he has not formally adopted the children. But where he has formally adopted the children, I guess the rights of the biological father may have terminated if the biological father gave consent to the adoption of the children. And that is where we say, family matters are very complicated. We need to ask ourselves first and foremost, is there a possibility of both fathers agreeing to mutually parent the children, or there will be competition? If that can happen, like it happens in the West, where, you could be a stepfather, biological father, and etc., and there be an agreement on parenting, visitation, and etc., I don't see a problem. But in our jurisdiction, the biological father would want to claim, or cling onto the children, and particularly if there is a benefit accruing from the death of the mother, maybe some payments from some mutual funds or some payment from, her employer and etc., he will resurface because of the money. But what is in the best interest of the child? And is he even a proper parent? Because when we talk about guardianship, adoption, and things like those, parental rights may be terminated by things such as, first and foremost, addiction to drugs and psychotropic substances. You are not a fit parent. You could also be mentally unfit because you are afflicted by psychological ailments, bipolar, things like those, and etc. Or generally, you have abused the children in a sexual manner. For instance, you have been found guilty of incest and things like those, which render you unfit. So in that particular case, I guess the stepfather may have to step in and to argue their case that they are the fit parent. What makes the biological father unfit? Courts may lean in the direction of the biological father, but is he a fit parent? And did he surrender his rights to the adoptive father if there has been a formal adoption? If they've not been a formal adoption, then the biological father is still the father. Because a lot of people don't see it through, to adhere to the law when it comes to the requirements of adoption. They may be living with the children, but they are not the adoptive parents, so to speak, because they have not filed the requisite proceedings, or even the children have not consented to being adopted if they are of a certain age. Yeah. So because they need to consent to being adopted. Yeah.
And I'm just imagining a scenario where the court finds the biological father unfit for one reason or the other to have custody over the children. And this stepfather is unwilling, to take this baggage on board. What happens to these children who are innocent?
I think that is where the guardianship by members of the immediate family comes in. Who are the immediate family members?
Yeah.
Yeah, in either related to their mother or the father, and who may be able to apply for guardianship proceedings to take custody of the children under their care. Because I think childcare institutions or children homes or places where children are taken in by NGOs, non-governmental organizations, charities, and things like that. Institutionalization of the care of children is something that I guess the Children's Act, the amendment, tries to negate. What kinship care is more preferable by those who are related by blood to the children as opposed to institutionalization of children, and particularly in this country where we have seen the commercialization of such agencies or places where people just take in children for the financial benefit that they get from donors, and also where we have witnessed cases, documented cases of sexual abuse of children by foreigners. So therefore, kinship care as opposed to institutionalizing the children in charitable care institutions.
Okay, thank you very much, Koki, for that clarification. And maybe back to you, Dr. Msembi. You did mention that both parents have, maintenance obligation, but I'm just imagining a scenario where the court has ordered maintenance, but the parent who is not with the custody of the child is unwilling to cooperate fully with the court orders. What remedy should I have as a parent that has custody of the children?
Okay, thank you. Before I answer that, I just want to add on to the scenario about the step parent and to point out that the Children Act does actually give the court power to make an order of maintenance for a stepchild. a child for whom you're the presumptive guardian, even if there was no adoption order. So in that sense, then the court can hold a step parent liable. There are several conditions, yeah, like showing that they were already maintaining the child, etc. So it's not entirely just up to your discretion, yeah. The court can, in some circumstances, find you liable as a step parent to be the one to pay the maintenance. Okay, so to the question that you asked about enforcing maintenance orders, right? The court, of course, the other parent can make an application to the court for that maintenance order to be enforced. And there are criminal sanctions. I just need to look up the section, but there are criminal sanctions for defaulting on a maintenance order, right? But the court first has to ascertain that the default is on account of willful refusal to pay. So they'll look at the means of the person against whom the order was made, and then they can take several measures. Of course, there are criminal sanctions, but that may not be effective. You don't jail the person, then they can't pay. So then there's also, they can levy distress on their property, they can attach your salary, they can call for statements from your employers or from auditors of your business to ascertain your means, and then make an order appropriately, not more than 45% of your income. And then the enforcement of it, the court could either order periodic payments, and if they were already ordered before, maybe they can vary that order and collect a lump sum or make the installments much more regular. You know, the court has such wide discretion in enforcing the maintenance order. Now, may I also add that it's not only the other parent who has the power to make that application. Any interested party can make that application on behalf of the child. So, I mean, the statute gives a very wide standing, right, or local standing. Any interested party. So it could be a grandparent of the child. It says any person, any interested party, any interested person. Okay. So there is a wide scope for enforcement, yeah. But maybe Koki can speak to, in practice, how does it work? Because reading the statute, it looks like there's every possibility for enforcement. Yeah.
I have not practiced in the children's court a lot, but what I can say is this. A lot of Kenyans don't have jobs. And in as much as the Constitution mandates equal parental responsibility, I guess it's Article 53, Sub-Article 1, either E or F, I think it's E, joint parental responsibility. Joint does not necessarily mean equal. And there are very many cases of Kenyans who may not be able to provide for their children on account of their economic status. They don't have jobs, they don't have income, and etc. The court may order and say, you pay this amount of money, either monthly or pay school fees periodically, and etc. and etc. Enforcement of those orders becomes problematic. You have to extract the court order, you extract the decree, then you have to file execution proceedings by way of a notice to show cause why you should not be committed to civil jail. And civil jail means that the plaintiff will have to foot your bill for committal to civil jail. The party may not even appear in court. Then warrants by the executive officer or the police officer to enforce those warrants. The party may not voluntarily submit to the jurisdiction of the court, and etc. It's very problematic. Okay, there's what the law says and stipulates, and there's how to actualize the law in terms of real proceedings. In the meantime, the lives of the children, at stake, food, shelter, clothing, school fees, books, medical, money for medical covers and resources, and etc. and etc. So there's the law, but then we need to also understand that realizing the letter and script of the legislation in a court of law may be very problematic. Which reminds me, I had one case where we got an order to attach somebody's salary, and he was paying regularly. Until one time, I got a letter from the HR department saying that he had been fired from that organization. But when I inquired and investigated, he was still working there. That was a way of circumventing the court order.
Mhm.
So
Mhm.
what would you do? Go back to the court? And what would you do when they say that he's not gainfully employed there? You know, there are
Mhm.
real problems of enforcing even the
Yeah.
provisions, some of the provisions in the Children's Act.
May I
And what
also
would you?
add?
Okay,
Sorry.
go ahead, Celeste.
Actually, by way of a question. So, of course,
Mhm.
it's very expensive to keep running back to court every
Yeah.
time someone defaults. So I know that one of the stopgap measures that people employ is to go before the children's officers, and then just get them
Mhm.
to write a letter or to the other person or to summon them to the children's department, in their ward or
Mhm.
county, and basically answer or get to at least make some kind of a commitment that they will henceforth, comply with the order of maintenance. And should they fail, then the children's officer will bring the complaint themselves. I mean, they're just forums that people use
Mhm.
in light of how expensive it is to keep going to court.
And perhaps would you propose,
And which may
Dr.
not
Sebi?
work. Can I interject? Which may not work because
Okay.
if a party is not willing to, voluntarily pay for their children, even if they
Yeah.
are summoned to the children department or children's officers office, what happens if they don't go? They don't honor the summons. There are even people who use chiefs, and if they go to lawyers, lawyers will tell them, find a way of settling this out of court, but you don't have to go. It's not a court order. So what happens now?
Yeah. Yeah. I think it's easy when the parties are willing to agree and negotiate on the way forward than when one party is disagreeing to the whole arrangement, which really puts the situation of the children, especially the young ones, at a precarious condition, for they are waiting for these maintenance resources to help them move on with their life. I'm just wondering, what would you suggest is the best way that our justice system can better enforce the maintenance orders? Do we have
I
a
think
way
I
forward?
think you'll have to invite magistrates to come to your podcast so that they can educate Kenyans, because what I have seen in the children's court, at least when we used to have physical courts and maybe you'd go to the fourth floor, a lot of litigants are impecunious. And there's also the misconception by women that it's men who are supposed to pay for children. And this one is based on cultural norms. And there's also the conundrum of a lot of single women who have had children with men who are not necessarily their spouses or partners, and are trying to file proceedings against parties who would not want, for privacy concerns, and even for the sake of their reputations, to be known to be the biological fathers of those children. So there are real problems there. So you may need to try and invite magistrates to your the ones in the children's court so that they can come and answer some of those questions.
Okay. Thank you for that. At least, we can always be positive and hope that one day there'll be a better way forward. And beyond the legal orders, what other social and psychological support is there for the children?
Sele, do you want to take that, or can I answer?
I can start off, and then you can
Yeah.
add to it. I remember listening once at a conference to some child psychologists speaking, and their view was, they were advising that, well, they were speaking mostly to some of us academics, and then some judges of the family court, and then generally people who had an interest in family law. And their suggestion to the judges and magistrates was that even when it hasn't been requested, if there's a possibility of ordering for psychosocial support for the child, so the children are accompanied during the process of, say, divorce proceedings by the parents, because the parents themselves may not identify the need or may not be able to afford a private psychiatrist or a counselor, to accompany the children through the process. So would it be possible to order maybe through the children's department? We do employ social workers and all that. So that was one that I had this child psychologists suggest. And then mean, not everything has to be professionalized. We also have extended family networks. So you're a party to a divorce proceeding. I would like to hope that you're not, antagonistic to everybody or opposed to everybody. Identify somebody that the children are close to, besides yourself, because in that heated context, you may not necessarily be you're yourself in need of psychosocial support, I guess. So much as you try to explain the process to the children, at least find somebody else whom they also trust, whose advice they value, to at least work with them and just be someone that the kids are free to talk to, just to speak their minds and their feelings, right? So just support them right through the process and don't assume that they understand it just because you've explained it. And I guess also a very important thing is to keep adult business adult. Don't drag the children in, especially putting them in a position of disliking the other person, hating the other person, feeding them with, that even if the details are true, there are things kids don't need to know. Don't burden them with that. Don't scar their conscience with that. Keep adult stuff adult. Yeah.
Thank you very much. Ms. Koki, do you want to add in anything?
I think after divorce, apart from psychosocial support by trained child psychologists, because not everybody is trained in child psychology, and you need to get those ones with a specialization in child psychology. I don't know how much expertise we have in that in this country. A lot of people in this country do not understand the need for counseling and psychosocial support. But the question here is really on the part of the parents, are they able to collaborate and agree on parenting? Despite the animosity, the hatred, the disappointment and the hopelessness that comes with the divorce. Because divorce comes, and I understand some people describe it as death. Of course, it is the death of the marriage, but it does not necessarily mean that the parties' relationship needs to be severed. The contract is terminated, but is it possible for the two adults to collaborate in parenting, and so that when they are in the presence of their children, they can reassure their children that the children will continue to get support from them, parenting support, even if they themselves as a couple no longer love each other? Do the children feel secure? Are they going to be, this idea, first and foremost, are they going to have the parents available in their lives? Or is it us pretending to be white people where somebody picks the children on a Saturday afternoon, then return them at this time and this and that and the other? That won't work. I guess there has to be a mutual understanding that parenting is a continuous role of both parties until the children attain adulthood at 25. And both parties, even if not together, and somebody has moved on with somebody else, they are available to parent their children. Despite the hatred, the enmity, and the marital discord that preceded the divorce, because there's always that, and hurt feelings, and you've been left, and etc. and etc. So there's a lot. There's counseling. But then, do people want to let their business, their private business of, their children out there? Sele proposed, family networks of, speaking to maybe grandparents, and there would be very appropriate parties in this conversation. But do we want to let them in? A lot of people are very private, and a lot of people don't want to air their dirty laundry, and they want matters to remain private because they are family. So even the people that are very close to the children and who may observe behavioral changes because of the trauma that divorce inflicts, like teachers, will not be told what is happening in most cases. And they're also trained. Some of them are trained in child psychology, and they can help the children. But do we want to wear our dirty laundry? A lot of Kenyans are very private. There's that issue.
Wow. Quite heavy issues. Let's now move to children and succession. when it comes to inheritance, and perhaps we can start with Dr. Msembi, what are the specific legal protection mechanisms that exist today, especially in consideration of the children?
I guess in terms of succession, the best way to ensure that your children are provided for is to write a will where you set out your wishes clearly and you make it clear which how you want your property to be managed so that it benefits your children. And in terms of legal protection, where the children are under 18, the law always requires that their share is held in trust for them. So a trust is established basically between the person who's the administrator, okay, the executor of the will, right? Or according to the directions that are given by the person who wrote the will. So that's really one sure. Of course, even why wait until you die? You know, you can also designate some property, say set up a fund which you've invested in for their education, and then you just make it clear how it will be managed, right?
Yeah.
So you don't have to wait until you're dead to be sure that your children are provided for. Now, I think it's an accepted fact that most people do not write wills in our context. Most people die intestate. That means you've died without writing a will. And so then there are some default provisions of the law that kick in. There's a process of identifying the beneficiaries. So you'll hear of people going to the chief to get a letter that confirms, yeah, this person, we knew them, they're from this area. We know their surviving spouse to be so-and-so, or spouses to be so-and-so. We know their children to be so-and-so. And that's the list that basically is tabled before the court when an application is being made for whoever applies to be the administrator of the estate, right? So that's also a measure of protection. The court wants to ascertain that nobody is left out, and that process is done openly, and all those people must appear in court to confirm, that they recognize each other, they are the beneficiaries and all that. But that process can drag on for a while, right? So it's safer to make sure that you've written a will. Yeah. But Koki can add to that.
Yeah, Koki, and as you add, perhaps also just help us understand what are mechanisms that are in place to ensure that property held in trust for the children is not mismanaged or abused by guardians.
Okay, fine. I'll add on to what Celeste said. If you look at the provisions of sections 35 to 41 of the Law of Succession Act, it appears as if the property of a deceased person who died without leaving a will devolves to the spouse and the children, okay, or grandchildren, if we are to go to section 41. Again, if you look at section 66, in terms of who has priority to the property of a deceased, spouses and children are included before, creditors and the public trustee. Now, with regard to probate succession, that is succession of a deceased property who left either an oral will or a written will. Yeah, this is the best way to safeguard your children by having them be the beneficiaries of your will. But then problems could arise even with the probating of the will. Those who have an interest in stealing the property will always and could always contest the validity of the will, and that will mean that immense resources, legal resources, financial resources are diverted towards paying lawyers, the court processes which drag on for many years, before the validity of the will is even proven and the will is admitted to probate. Again, if you have if you had not appointed your own children as both beneficiaries and executors, particularly if they are of age, you appointed an executor who is not, related to you, or a person who is not, a person who is not has no financial integrity. They could try to sabotage even the provisions of the will to ensure that they keep and they drag this matter in court to circumvent your wishes as a deceased person. Why not just transfer the property to the children if they have attained the age of 18? And if it is pension monies or provident funds, why not just nominate them to be beneficiaries of these resources? And if they are minor children, because there is a requirement of appointing, if you're dying intestate, it's called a continuing trust, sections, I guess 75 and 58 of the law of succession. Whoever is appointed to co-manage the property of the deceased with the administrator must ensure that the property is safeguarded and not wasted, and must adhere to the directions of the court on particularly real estate. A continuing trust means that the administrators must ensure that the property is not stolen. I don't want to use, they have, a fiduciary duty, but that means that they ensure that the property continues being available to the children, even as they attain the age of 18. But then if they have attained the age of 18, you could also always do an inter-vivos transfer during your lifetime to their names. But then I wonder, if you do that, what stops them from evicting you from your own home? That's another issue.
Yeah.
You transfer the property to them, and what stops them from selling the property? Unless you do it and you do not disclose this information from them, it can be tricky. But as far as succession is concerned, even with wills, I'm involved in litigation where I've seen a lot of corners where you could have left a will, but still there are problems.
Yeah. And also a will can be challenged. So
It can be challenged. You asked about the legal provisions that are now there to safeguard children. I guess also the provisions on dependency, where if you are not necessarily the known biological child, but you are a child of that person. For instance, you're not a child of the spouse, and you're a child of maybe a partner, or like we like to say in Kenya, mipango ya kando. Those children could also apply for a share of the deceased estate, whether or not there's a will. In intestacy, where there is no will, they can apply to be recognized as dependents of the estate, and for reasonable provision under Section 29A, and even Section 29B. Even if there were stepchildren, for as long as they were being maintained by the deceased, they can apply for reasonable provision, whether or not there is a will. That's another mechanism that is there in the law of succession to safeguard the rights of children, when a person dies.
Okay. Thank you for that, Koki. Yes, please go ahead, Doctor.
Yeah, just the question that Koki raised of if you transfer the property during your lifetime to your children, what's to stop them from turning against you or evicting you?
Yeah.
I wonder whether there's a safeguard in a joint registration. You register yourself as a joint owner with that child. So joint ownership comes with the right of survivorship. So if biology is to work, it means you will exit before they do. So they survive you, and then the property only becomes fully exclusively theirs after you die. Right?
After you
Of
die.
course, the biology.
I think that's a very that's a sure bet. That's a sure bet. Yeah, survivorship. Yeah, would work.
Also, you don't have to tell them. You don't have to tell them.
I know.
You can
conceal the information.
Exactly, and have someone release it when you've died, so they have no way of knowing that. Oh, let's evict the old, the old lady, and then let's now take over the property. Yeah, thank you.
Okay, thank you very much for
That is
interest. Yeah. Now, we all also acknowledge the fact that we live in a very patriarchal society. Yeah. How has culture, customs influenced this inheritance, especially when we look at it from the children perspective?
I think from the succession cases I have seen, a lot of people do not understand the provisions of sections 35 to 41, that when a deceased dies, preference is given to their spouse and their children. And so that if you are related to somebody as a brother, sister, parent, and etc.,
Yeah.
people always have an expectation of inheriting. And if they died intestate, there's always, you may find people filing all sorts and manner of proceedings in court, protesting, objecting to this and that. They will object to the grant being given to the, to the widow or the widower and her children. They will say they were being supported, and they will protest, to the confirmation of grants, without knowing that they just need to apply for reasonable provision under Section 29B. But they must prove that they were being provided for by the deceased. They're not being given a share of the deceased estate. They're being given reasonable provision, commensurate to what the whatever upkeep or financial assistance they were getting from the deceased during his lifetime. So we don't understand the law. Living in a patriarchal society, for instance, if a man dies and he was wealthy, you will find family members, brothers and sisters, even the parents, trying to take the property away from the widow and the children, whereas they have no entitlement in law. They would only apply as dependents under Sections 26 and 29, but here they come wanting a share, and in most cases claiming that the widow and the children or the widower is getting too much and they are getting nothing. In patriarchal societies, men acquire a lot, and the being seen as the heads of families, there's the customary or norms based on culture that the person belongs to the family, and the family is the kin and the kith. So he was providing for them, and he should continue providing for them even in his death. And what would they do? And that is why we have a lot of cases in court, as people are trying to fight for things that they have no right to.
Yeah. Thank you very much. Dr. Msembi, do you want to add anything on that?
Yeah, and I'd just like to say that actually what you get to see in the succession disputes in the courts, I believe the percentage is like 1%, of the, that's only 1% gets settled in court or get resolved in court. The majority of the succession issues are handled outside of the court system. And that's not necessarily a bad thing if it means that people are able to discuss within the family and agree. Okay, so they're amicable ones, right? But unfortunately, there are also those where those alternative sites become sites of oppression. And really for the most vulnerable at that time, who are, the widow or widower in some cases. Yeah, widowers can be quite vulnerable sometimes. And children, but particularly children, right? Where you've had children drop out of school because suddenly their life circumstances have changed, and the adults don't have their interests at heart. They're busy fighting for who gets what. And by the time the dust settles, that's a life already, life chances already ruined, already destroyed, right? Because people believe that, okay, by custom, you, widow, you just came to this family. It's like you never really acquire a permanent position there. So your husband dies, and now you're supposed to be this person who has no identity in that home, or you're basically rendered homeless, landless. I think, as Koki is saying, it's based on a misconception that you have an automatic claim as extended family, whereas actually in law you don't, right? It doesn't mean that you have no claim at all. You can get provision if you show that that was your, where your support was coming from. But the claim of the immediate dependent, automatic dependents, the spouse and the children, are what the law puts first. And I think we need to get people to understand that. Of course, it would be contested by those who believe that property belongs to the lineage, and now you have become an outsider to the lineage, and you are, especially if you're a young widow, you're always viewed with suspicion. You may very well remarry, and what happens to the property that we give you? You're going to take property out of our lineage. I think we need to just get people to understand that the law doesn't work with those assumptions. If someone in fact does remarry, well, that's already contested territory, because our law actually did say in the law of succession that if a widow remarried, she lost the life interest in the property. But that has changed with the case that was litigated. I believe the date is 2018. I have to check. Ripples International versus the Attorney General. That section was actually ruled unconstitutional. So actually, as we speak now, no widow should be losing their life interest in the property when they remarry. They're as free to remarry as a widower is. But do people know that? I mean, so I'm just saying that
No.
people need to, make it their business to know what rights they've got. And knowing your rights doesn't mean that therefore means you're preparing for war, you're praying to go to court. No, knowing your rights just puts you in a better bargaining position. Even if you're resolving the dispute in those alternative forums, you are in a better position because you know where you stand. No, in any negotiation, any bargaining, a party knows where they stand, and so they're able to pursue their claim with confidence, right? So even if you don't plan to use the formal legal forum, the knowledge about it gives you a bargaining position in the informal settings where you negotiate. Yeah. That's what I would say.
Thank you very much for that enlightening. I'm sure quite a number of the audience have learned a lot tonight. And now I would like us to take a few questions in the interest of time. Our first question comes from Lata Hussein. And Lata is asking, how can the jurisdictional separation between divorce and custody proceedings lead to conflicting orders? And what strategies can ensure that children's best interests remain paramount in both forums? So maybe we can start with Ms. Koki.
I know how that can happen. First and foremost, the court that has jurisdiction to hear and determine matrimonial proceedings does not necessarily deal with children matters. Children matters are dealt with by the Children's Court. But then in our jurisdiction, the High Court may be issuing these orders in the matrimonial proceedings or directions, and in the Children's Court, a magistrate may be issuing, different orders and etc. And this is because the matrimonial proceedings are predominantly between the two parties, and they concern either separation, divorce, or matrimonial property. And the children's proceedings concern the best interest and the welfare of the children. So when she says conflicting orders, is it orders that are inimical to the rights of the children? For instance, divorce would be inimical to the rights of the children. An order for judicial separation may be inimical and not in the interest of the rights of the children. Most disputes in the Children's Court concern maintenance and money. That is what we have in our jurisdiction, or visitation rights or guardianship. That is what we have. In fact, I would say, although I've not done the research, but I would say from my observation of what I used to see when I used to go to fourth floor, the Children's Court is predominantly concerned about the rights of children under Article 53, school fees, food, shelter, nannies, medical, books, and things like those, okay? Rarely would you find, somebody applying for visitation rights and things like those. The litigation is predominantly about money. So I'm imagining proceedings relating to how matrimonial property will be shared. If one party is getting a bigger chunk of the property to the detriment of the other, that could also hurt the children one way or another. So is that what they mean by conflicting orders? Because the divorce court or the Chief Magistrate's Court, if that is where the divorce proceedings are filed, it concerns the provisions of the Marriage Act, and not the Children's Act. But then why is it that where proceedings concern parties with similar names, on the judiciary portal, a magistrate or a judge is not able to also, see what is happening in other courts concerning these same parties? In other words, linking in the portal. And so that, for instance, in jurisdictions like the UK, if there were proceedings in the Children's Court, and there are also proceedings concerning the parents in the family division, which is also still the family division, a judge issuing orders in the family court is able to see what is also happening with regard to proceedings concerning those same parties in the children's court, or if there has been perhaps a case of domestic violence, a magistrate, dealing with, custody issues and etc., would also know that there's this order relating to domestic violence against this party. So the probability of conflicting orders is minimized. But our courts are very manual. And even though we have the judiciary, the CTS, and orders are there, in most cases, when we are conducting proceedings in court, a judge or a magistrate is just writing, and dependent on what they are being told by counsel, who may mislead if they decide to do so.
Okay.
Could I just add that the
Yes.
Children Act has sort of tried to take care of that possible conflict. I think the section is 112. You can cross-check that later. But basically it says that the court, meaning in this case children court, can make an order of maintenance, notwithstanding whether there are divorce or nullity proceedings affecting the marriage, right? But it says that where the children court is seized of jurisdiction in that matter, then no similar question, the same issue of maintenance or related issues like custody cannot then be raised in another court without leave of the children's court. So there's been an attempt to harmonize so that you don't have conflicting proceedings going on at the same time.
Okay.
Yeah, but the family division, the magistrate's court that would deal with separation or divorce, has no jurisdiction to deal with maintenance of children. That is predominantly in the children's court. And similarly, the children's court has no jurisdiction to deal with spousal support or sharing of matrimonial property. I understand what the act says, but I'm talking about the conflict of, and I guess the viewer is asking about conflicts which may arise and orders which are inimical to the rights of the children made by other courts. And maybe they are looking at it from the perspective of, is divorce even in the interest of the children? Even is an order that says that the spouse cannot get maintenance in the interest of the children, things like those. At the same time, the children court may have ordered a party who is not working to pay maintenance, and the same party is being sued, in another court. So in their perspective, whoever is asking, this could be conflicting orders, but they are not, because the children's court is there to protect the children. And these other courts are there for parties to litigate their rights, to divorce, matrimonial property or separation, and things such as those, or even declaratory orders that, this is matrimonial property. But what do they mean by conflicting orders? I don't understand, but I think I have an idea. See, what we may view as conflicting orders as lay people is not what the law says, about, this or the other.
Okay, and the second question I think is also closely related to the first one from Gabriel Juguna. When parties fight over custody, is it about interest of children or the parties to marriage?
I don't know. Custody relates to who has, who is parenting the children at their home. Is that what it is?
Yeah. Yes.
Or what are they asking? Do many people want custody without money?
I think
in Kenya, everything revolves around money.
The question is expressing some skepticism as to whether it's always possible to separate between, self-interested action and then action that is in the interest of a child. Because I guess if you ask the party that's fighting hard for custody, he or she will say, I'm doing this in the interest of my children. Yeah. But, I guess it's for the discerning, judicial officer to figure out, on which side the interest of the child lie, right? Whether some other agenda is being clothed in the language of the best interest of the child.
Okay, thank you. Jennifer Mumbi, does the adoptive father adopt children by mere virtue of being legally married to the mother? Or is there a legal process?
No, he has to file proceedings. He has to file proceedings to adopt children, that he has not biologically fathered, and the biological father must consent, in which case, in most cases, men won't consent,
Yeah.
even if they don't want the children, just out of ego. They will not consent. Yes. We have to look at the practicalities of the law, and the children must also consent to being adopted if they're of a certain age bracket. So I don't know whether there are very many cases of remarriage in Kenya of women in certain age brackets, because is there the concept of calling women mitumba? You also must find a way of making this podcast interesting, Evelyn. I've heard of the concept of mitumba, and a woman who's had children. I had it on is it TikTok or Instagram? And
I have not
Kenyan
heard
men,
of it.
they're called mitumba. You look for the street language. If you've had children and etc., the possibilities of remarriage, if there are no vested interests on the part of the parties who are coming in to propose and take you on. Okay, so adoption and things like that. There are very few takers. If you don't have money and you have children, and you are looking for a man really to partner with, to take care of those children and just to continue life. A lot of men don't want to, formally adopt children that they have not biologically fathered. That's also Kenya. We must look at the social cultural context of the happenings in our country, because you see, adopting children comes with burdens. They will inherit your property eventually when you die. And culturally, now that your program has got, your questions are lying to cultural connotations of things. Culturally, if they are not yours, from the perspective of birth, you fathered them, the community will not want them to inherit anything. You're getting where I'm coming from? Yes.
Okay, thank
A
you
lot
very
of
much,
people
Koki.
are still aligned to cultural values and norms in this country. So we are not westernized enough, even though we pretend to be.
Okay, Gibson Katana. What happens when a mother divorces his husband and remarries with kids, and the children still have their biological father and also the stepfather? Then a few months later, the mother dies. Who takes the responsibility?
I think it's time you ended this podcast, Evelyn, because we have answered those questions.
Okay,
Unless
hello,
Dr.
Dr.
Celestine
Msembi.
wants to keep, go on.
Okay, Michelle, hello, Dr. Msembi and Dr. Koki. Kindly share your insights. In what ways do courts navigate the conflict between inheritance in Islamic religion and constitutional guarantees of equality for children?
I'm not an expert in Islamic law, but Saleh has written extensively on that. Maybe
Not
she
extensively. Not extensively. But well, I guess maybe some of your viewers are students who've either done family law in the past or are currently doing it. Those who are currently doing it know that we've assigned a lot of articles from the recent special issue of the East African Law Journal on marriage, property, and equality. And one of the articles there by Dr. Moza Jadid is actually on the question of developments in Islamic family law. So at the time of writing, the case of Faraj versus Mwawasi was going through it had actually been filed in the Supreme Court. So this ruling came out, I believe, in September, if I'm not wrong. I think it came out either August or September, the final judgment in that court, in that case of Faraj versus Mwawasi. And that was the question that arose, where a Muslim man had fathered children out of wedlock. So during cohabitation, but had not formally married this woman. They subsequently entered into an Islamic marriage, but the children had already been born during the period of cohabitation. And so now there was a rival, it was contested, whether these children were properly heirs under Islamic law. Because Islamic family law basically says that if your child is born out of wedlock, they cannot inherit property from a Muslim man. Okay, so he's their biological father, undisputed, but they were born out of wedlock. And all the way to the Supreme Court. Supreme Court said the Article 53 basically trumps the application of all those principles under Islamic family law. And yes, Article 24.4 makes that exception to the equality clause, right, to say that equality, the interpretation of equality may be limited to the extent strictly necessary for the application of Islamic law before Qadhi's court and all that. But the court basically said that Article 24.4 doesn't mean that there's a blank check for Islamic family law to trump Article 53, for example, or other constitutional provisions. So as the law currently stands, articulated by our Supreme Court, you cannot apply, you cannot disinherit children or prejudice them because of Islamic family law, or indeed any other law, right? Whether it's customary or indeed a statutory law that purported to do the same would be found to be foul of the Constitution. Yeah, so that's the balance that we have here.
Okay. Maybe we can move to the next question from Eric Kibogo. On matters divorce, there is an apparent shift from fault-based to non-fault-based considerations. What do you see as possible unintended consequences on the sanctity of marriage as an institution?
I see Koki disagreeing. We haven't moved away from I think that's what people had hoped, including me, actually. I had hoped that with the 2014 Marriage Act, when I saw the prominence given to irretrievable breakdown, that we are finally moving away from fault-based a divorce, to no fault, where it's a more civil, more amicable. But I think what I've heard from, even judges and other practitioners is that no, we really haven't. Irretrievable just means that you can bring a range of other factors, including the specified grounds to show. But there isn't anything like we just want to move on. Yeah, you don't get a divorce in Kenya by simply saying we want to move on. Yeah, but let's hear Koki, because I saw you make a face when the question was read out. So you must
for me, I think we lag behind in our law. Why don't we move to a no fault-based grounds, not just the ones that are traditionally known, because those ones in most jurisdictions, people have moved beyond that. So if the marriage is irretrievably broken down, parties should have the liberty to file and to have the marriage terminated. After all, this is a personal relationship between two people. Why should the law hold them captive, that you have to satisfy these grounds, adultery, cruelty, irretrievable breakdown? If it has irretrievably broken down, or even where people consent to divorce, they should be allowed to do so. After all, Islamic law allows divorce by consent, where the parties feel that, the marriage is no longer viable, they can divorce. Consent. How come these other marriages, Christian marriages, civil marriages, Hindu marriages, and even, I guess, under customary law, you must be held, to the institution of marriage and what people are calling sanctity. Sanctity is a Christian doctrine that, marriage is for life and you have to stay married. But a lot of people now, first and foremost, are not marrying. A lot of people also want to be happy. So why should you have to spend lots of money in a court of law before a stranger litigating matters concerning your personal life to prove certain things on a preponderance of evidence? Why should that happen? We amended the Marriage Act in 2014, but I think it's ripe for amendment. And let us move on to what has happened in other jurisdictions. But I don't know whether our legislators who represent, huge constituencies of mindsets of people would support that. They say they represent the people. Who are the people? What do the people want? What do the people want? Do they want to litigate, their personal lives before judges and magistrates? Or can you just file and if you've both agreed that this is not working, an order of dissolution is given, and then we move on to the next proceedings? And in fact, I have seen one case where the court that does, in a non-fault-based jurisdiction also determines the question of division of matrimonial property. In those same proceedings, you don't have to adjourn and file separate OS, an originating summons, a new suit to divide matrimonial property. The court can handle that, and you share and move on. But
Mhm.
here in Kenya, those proceedings relating to the sharing of that property can also take another 10, 15 years, as between the High Court and the Court of Appeal, by which time people are old and will not even be able to enjoy the property or dead.
Mm. Yeah.
Yeah. So we need to amend our law
Mhm.
in
Okay.
tandem with the
I don't know how
Better.
much time we have left, but I just
Yeah.
like to.
Mhm. You can add, and we take one last question.
Okay, so I mean, just before we started this podcast, I mean, Koki was teaching, and the topic is actually procedures in divorce, and but she had to deal with the preliminary question of a bars to divorce, when a court will actually not even entertain the proceedings, and one is connivance, right? If the parties have actually colluded or agreed to divorce, you know, the logic of that is you want it so badly that both of you want it, so we won't give it to you. It doesn't add up. So as she said, in other jurisdictions, it's moved on, right? The question is, going back to what we were discussing earlier about the best interest of the child, right? If to insist on a fault-based system makes the proceedings so acrimonious and so adversarial that actually there's great harm to children, right? Should we think about it, even if not for any other reason, but for, you know, shielding children from this kind of acrimony that goes with, you know, having to prove one of them was at fault, right? But also, may I say that even if we don't get to dismantle the fault-based system altogether, can we at least delink marital fault from fitness for parenting, right? And I was surprised to find that we still have that link. You can look it up, Section 103, subsection 4 of the Children Act, where it talks about if the parent who was denied custody had also been found to be at fault in the divorce proceedings, should the custodial parent die, he or she isn't automatic. The surviving parent is not automatically entitled to child custody. It has to be approved by the court. So I thought, okay, I mean, those are two things. Either you've been declared unfit as a parent, that's one thing. You have been found at fault for the divorce, that's a different matter. Why are we linking them? Yeah. Why don't we, if it's about concern for the child, any parent who had been previously declared unfit should not automatically become the preferred parent because the other one has died. The court has to approve it. But it's being linked to if this parent who was unfit for parenting had also been found at fault in marital proceedings, that it doesn't connect, you know. So even if we don't dismantle the fault-based system altogether, can we start here? Can we start by delinking marital fault from fitness for parenting, for custody, okay, for parental, for children,
Okay.
child custody. Yeah.
Oh, thank you for that, Dr. Msembi. Let's take one more question. I'm sorry I will not be able to, voice all the questions. I'll leave others pending, but we can still continue the discussion some other time. To what extent can a parent use a parental responsibility agreement to preempt litigation? And what are the legal and practical limits on modifying such an agreement post-divorce?
I think a parental responsibility agreement is a feature in the Children's Act where parents may voluntarily, either by consent, and there's a format for such an agreement. I guess it was, at least it was there in the Children's Act. It's there in the Children's Act 2022, or by consent in court, agree on how much they want to contribute towards the maintenance of their children or on matters parenting. That's a parental responsibility agreement. What is the question again? Altering it.
Yes, post-divorce. What are the limits, the practical limits?
I think those are two different courts, if you ask me. Post-divorce, why should the parental responsibility agreement, the terms, why should they change? Is it because one party has received more in matrimonial property than the other, maybe a rental property, and therefore because they are more endowed financially as opposed to the other parent, they need to contribute more? Or is it because, and even parties may voluntarily change it. Why should personal relations, that is how people parent their children, be governed by documents in court? Supposing today I had a job that paid me only 50,000, and tomorrow I procure another job that pays me 300,000. Why can't I tell my partner whom I divorced, let us alter this parental responsibility agreement between ourselves. Now I can contribute 100,000 to the upkeep of the children, as opposed to previously when I gave only 18,000. Why should the parenting of children be the prerequisite or through court-ordered decrees? Why should it be that way? And I'm very happy a lot of people in Kenya don't use the courts. People don't know that. They don't use the courts in succession. They don't use the courts in child maintenance issues, and they don't even use the courts in anything. Okay? People have stopped using the courts. There is a decline in the usage of court processes. I know a lot of people who don't go to the courts for succession, for anything, because people don't trust the courts. They don't trust lawyers and they don't trust the courts. And that is with due respect to the system that we have in this country. A lot of people don't even know anything about the courts. And that's a huge chunk of the Kenyan population. And they don't care. I believe the courts are for the elite. This profession is for the elite. People who want to do succession, people who want to probate wills and things like those, people who want parental responsibility agreements and etc. People are now even, conveyancing is done, people just walk into lawyers' offices and say, Mr. PAE. Okay? So the law is not what it used to be. And we continue to enact legislation, but I don't know how many people use the courts or how many people obey even court orders, and
The court orders.
how many people obey court orders? How many proceedings do you see every single day on contempt of court and sentencing of people who have, disobeyed court orders? We need to ask ourselves those questions. Yeah.
Wow, thank you very much. I don't know if Dr. Msembi, you have any concluding remarks on this?
I would just like to say that, to the extent that people can actually manage their own affairs amicably, whether it's parental responsibility orders or making it clear what wishes they have for how their children's guardianship will be organized after they die, the more you can do that at your own personal level, at the interpersonal level, the better, because the court atmosphere, well, it's a last resort, I would say, that's the way it functions. But on the question that person had asked, yes, you can have the joint parental responsibility agreements or a co-parenting agreement, but remember that in the interest of in the best interest of the child, a court can, at its own initiative, review those agreements, on the application of any of the parties. So always remember the paramount consideration is the best interest of the child. So you can't bargain away the basics, that impinge on the child's rights, for example.
Okay, thank you very much. And if there is anything we should all remember, it's the best interest of the child, if not anything else. And so I just want to take this opportunity to thank our great experts in this area, Dr. Celeste Msembi, Ms. Evelyn Kokimbulu, my namesake, and just to extend a big hand of thank you to both of you and to our audience as well. So please subscribe to the channel and make sure that you join us next time we are having this kind of conversation. Thank you and God bless you.
Thank you for inviting us, Evelyn.
Yeah, thank you for having us.
Good night.
Great. Thank you. Good night.
Good night.
Thank you. Night.